My Lord. My Lord, the present rate has been prepared in order to quash and modify the order dated 8/9/2022 in appeal case number 119 of 2022, wherein PG has been imposed of 5 lakhs upon the petitioner, which was exorbitant for the petitioner, my Lordship. My Lordship, the brief facts of this case is that a plot at measuring an area of 43,560 square feet was allotted to the petitioner, bearing plot number 83P. In the year 2022, wide allotment letter 231 dated 7/4/2022 for rigid PVC HDP LDP pipes, my Lordship. My Lordship, the unit was approved for a cost of approximately 2,21,99,990. My Lordship, the petitioner was about to deposit the first installment, which was approximately 6,61,000 within the time frame, that is 60 days of the allotment. In the meantime, my Lordship.
Have you deposited this amount?
My Lordship, I am coming to the point, my Lordship.
Have you deposited?
No, my Lordship, I have not deposited. There is a genuine reason, my Lordship. I have been suffered with medical ailments, my Lordship.
That was earlier. This order which you are challenging, 1st of September 22,
my Lordship,
asked you to deposit within 1 month the 30% lease money.
My Lordship, the order dated 11/11/2022, my Lordship, wherein the court was the Honorable Division Bench has ordered that to deposit the 30% of the to initiate production and to initiate the production within the time frame of 3 months, 6 months, and 9 months. That is the Division Bench order, my Lordship, wherein the respondent had clearly stated the facts that there is no third party right on the land, whereas the order was wherein the petitioner the undertaking which has been produced, with the undertaking which was to be produced according to the order of the division bench. But on the next date, when he was about to service the undertaking, my Lordship, they have opposed that thereby saying that there is a third party right, my Lordship. But initially, on 11/11/2022, they have right away said that there is no third party rights on the appropriate on that very land, my Lordship. Based on that reason, based on that facts, the division bench was about to give the benefit of the undertaking to the similarly situated allottees of Biada, my Lordship. And my Lordship, it could be seen from the counter affidavit, my Lordship, that on page number 8 of counter affidavit, they have allotted the land to a third party on 14/10/2022, my Lordship, wherein they have disclosed the fact on 11/11/2022 before the division bench that there is no third party right on the land, my Lordship. They have made a frivolous statement that they have not created third party. After that, they are coming with the same statement that they have created the third party right upon their land, when there was one of the provision of the division bench that if there is no third party right on the land, then only you will be getting the benefit of the undertaking, my Lordship. And within 2 months, my Lordship, the allotment is on 7/4/2022 and the cancellation could be seen on 23/6/2022. Within the 2 months of the time frame, they have created third party right upon the land, my Lordship. I have preferred the cancellation against the appellate authority, wherein the appellate authority has acknowledged the fact.
Mr. Counsel,
My Lordship,
your bona fides are not clear. You first of all did not deposit the 30% amount within the time frame laid
my
down.
Lordship, it was only a delay of
Please listen to the court.
Yes, my Lordship.
Then on 8/9/22, they held a meeting. Principal Secretary granted you 1 month's time to deposit 30% amount.
My Lordship, I was depositing the, my Lordship.
Just a moment, please listen.
Yes, my Lordship.
Completely. Sorry. And then answer.
Yes, my Lordship.
8/9/22 means 30 days means what date?
My Lordship, it is approximately 9/9/2022.
8/10/22.
8/10/2022.
Right?
Yes, my Lordship.
You do not deposit it by 8/10/22. You come to the court in November 22 and say that these conditions are harsh. They have in the meanwhile, because you did not deposit, they have allotted it
My
to
lord,
someone else.
I was coming to deposit the,
You have not.
deposit 30%, they have
Tell
levied
us,
the 5
tell
lakh
us in
BG,
your,
my lordship.
tell us in your petition, why did you
My
not
lordship,
do?
they have levied a 5 lakh of BG upon the petitioner, my lordship.
That is a subsequent condition. First is that you must deposit 30%.
My lordship, I was ready to deposit, but they have came with a
What?
condition that you have to deposit the
Anything
BG of
else?
5 lakh,
Nothing.
along with the 30%.
I'm going to impose a cost on you.
My
Trying
lordship,
to
they
mislead the
have
court.
initiated 5 lakhs of bank guarantee, my lordship. How can the petitioner deposit 6 lakhs and 5 lakhs of BG at the same time, my lordship?
It is not shall. He says he may also submit a bank guarantee
No.
in support of his claim.
My lordship, similarly situated allottees, he have cleared the fact that if you will not deposit the bank guarantee.
To you it was not there.
My lordship.
To you it was not such a condition.
My lordship, it was a condition given to the
others might, we are not bothered about others. In your petition, you have been granted indulgence, you have been also said that you may cannot be treated as shall.
Without
But,
the bank guarantee, my
but
lordship,
you did not even deposit that 30% amount within not 1 month, even in 2 months. Even till date you have not deposited.
My lordship,
and your intentions don't seem to be clear. Now you say that third party, you knew it very well that third party allotment has already been done.
No, my lordship.
You did not impede them as parties.
The fact that there are no third party rights upon the petitioner. My lordship.
Nothing.
My lordship, the BG which has been imposed is not within the Biada rules, my lordship. They are not obliged, or they are not within the conditions to provide a BG.
It is not imposed. It is an additional condition because and granting you an additional indulgence. The principal secretary has granted you additional indulgence, which was not there under the rules.
My lordship, within 60 days, he was with a medical illness, my lordship. Throat illness was because of the petitioner, my lordship. That is the reason he was not able to deposit within time, my lordship.
See, these are industries.
My lordship.
Here, personal illness does not have any room. You can't be saying that I did not join service because I was unwell. That is not a ground you can take in matters of setting up industries.
My lordship, I was.
यही अच्छे एक्सक्यूज लेकर आते हो.
My lordship, हम उसको डिपॉजिट करने वाले थे. My lordship, 5 लाख का बीजी अगर लगा दिया जाएगा तो फिर दोनों अमाउंट आप एक टाइम में कैसे डिपॉजिट
करने तो वाले बहुत कुछ चीज थे, करा कुछ नहीं है.
My lordship, हम देने के लिए तैयार थे, लेकिन 5 लाख का बीजी मेरे लिए पॉसिबल नहीं था.
अब now the third party rights have been created, nothing else can be done. You have lost the chance.
थर्ड पार्टी राइट तो माय लॉर्डशिप वो चीज फैक्ट को देखा ही नहीं गया ना माय लॉर्डशिप. हम तो देने के लिए तैयार थे, लेकिन 5 लाख का अगर बीजी भी इंपोज कर दिया जाए तो दोनों चीजें कैसे दे पाएंगे एक बार में.
We are looking at other things. You have filed this petition on 11/10/22, 18/10/22.
Yes, my lordship.
That is noted in the order number 3.
Yes.
Then
But my lordship,
that is beyond the period, and that shows that you never intended to even deposit 30%.
My lordship, I was ready, my lordship, but for BG, how can the man can supply both the things at the same moment, my lordship?
It's not at the
Within
same
1 month, you have to deposit the BG and the amount. Within 1 month, approximately 11 to 12 lakhs rupees you have to deposit within the month. For that, I approached to the High Court, my lordship. Okay, how can the petitioner deposit the BG, which is not under any Biada rules, to impose BG upon the petitioner, my lordship? There is no rules upon the Biada authority that they have to impose a BG. Additional cost they have to impose upon the petitioner in order to avail the allotment policy, my lordship.
Anything else?
My lordship?
Anything else?
No, my lordship.
Okay. The petitioner, by way of this petition, assails the order dated 8/9/22, whereby the principal secretary has noticed and passed an order granting 1 month further time to the petitioner to deposit 30% of the lease amount, which was originally required to be deposited within 60
My lord, I will
days.
deposit the same today.
Please don't interfere in. I asked you anything else, you said no. Within 60 days. The principal secretary further allowed the petitioner to start the unit within 6 months, failing which he was directed to hand over the land to Biada without recourse to any further legal remedy. Additionally, he was also asked to submit a bank guarantee of rupees 5 lakhs in support of his claim, which can be forfeited if he fails to start the unit in 6 months. The matter was further directed by the Principal Secretary to be placed on 11th October 22. However, without depositing 30% of the amount within 1 month, the petitioner referred this writ petition before this court. On the specious ground of condition of imposing of 5 lakhs bank guarantee. The writ petition was filed on 18th of October 22. This court initially had directed the petitioner to file an undertaking to this court to the effect that within 60 days he will start commercial production in the unit should the respondents hand over possession of the premises to the petitioner. Directed as under क्यों कर दीजिएगा, इसको कोट कर दीजिए as agreed. The said order was passed on the basis of statement of the counsel for the Biada that as on date third party rights had not been created. On 24/11/22, the counsel for the Biada informed that the unit already stood allotted to third party for a sum of rupees 1 crore 90 lakh 32,090 deposited on 5th November 22. This court therefore directed the parties to maintain status quo as on date. Learned counsel for the petitioner submits that the condition of bank guarantee was cumbersome and there is no such condition provided under the rules of allotment. The condition was beyond the rules and therefore the order dated 8/9/22 itself could not have been passed. I have considered the submissions. It is apparent that the petitioner has tried to mislead this court. Originally, the petitioner was allotted the land on 20 wide order dated 22/4/22.
Yes, my lordship.
And
738
on a lease amount and other charges of sum of rupees 2 crore 21 lakhs 90 9,999. However, he did not deposit even a single penny from April 22 till September 22. In September 22, the Principal Secretary again granted indulgence of 1 month to deposit 30% of the lease amount, which was also not deposited by the petitioner, and he, instead of complying and asking for relaxation of bank guarantee, proceeded to prefer a writ petition on different premises altogether. The bona fide of the petitioner company are thus found to be missing. This court is of equity, and the person who comes before this court must come with clean hands. A person who has failed to comply with the conditions of allotment and also further not paid the amount as given by additional, as allowed by additional indulgence, cannot come before the court and claim equity. It is noticed that the original amount on which the land was to be allotted to the petitioner is much higher than the amount on which the land has now been allotted to one other party. The respondents have thus already suffered loss because of the said aspect. In the circumstances, no further indulgence is required to be granted to the petitioner, since he has not paid a single penny. No right has been created in his favor. Writ petition is devoid of merits according to justice. It costs of sum of rupees 20,000 to be deposited with the legal services authority.
My lord, may I bring to attention that the amount which is to be realized from the second allottee, the third party, that is annexure 1 to my counter affidavit. There it is, my lord, about 4 crore 85 lakhs 10,000.
You have mentioned 1 crore.
Maybe that was the amount they have deposited as a initial payment, my lord.
You should say that you did not, when we said that it is at 1 crore.
My lord, that was the amount they have deposited. In the allotment letter, it is written, my lord.
The amount already deposited by the other party to whom allotment has been made is almost is of considerable amount, is considerable kar do. It is informed that the total amount on which the land has been now allotted is 4 crore 85 lakhs 10,000.